Hello, my name is Curtis Morrison. I work with my colleague Rafael Urena, and we have filed 3 lawsuits on behalf of DV-2021 selectees this year. This video gives an update on what is happening in those 3 lawsuits as of June 21st, which is today, Monday. So, 3 lawsuits. Jacob v. Biden, filed in January. Ray v. Biden, filed in March. And Good Luck versus Biden, filed in June 6th. First, let's talk about Jacob v. Biden. That's the lawsuit that me and Rafael filed in January. Okay. On June 8th, this month, Judge Chen issued an order in this lawsuit that dismissed the claims brought by the plaintiffs who were family preference visa category visa applicants, okay? And he kept only the DV-2021 selectees, about 380 are in that case, as plaintiffs and their families. So he ordered the Jacob plaintiffs, which is now the 380 DV-2021 selectees and their families, to file 1, an amended complaint, 2, a renewed motion for class certification, okay, to make the case a class action formally, and 3, a renewed motion for preliminary injunction. The deadline for that is June 22nd, tomorrow, but you may be seeing this tomorrow. So this is important news for the DV 2021 selectees who are plaintiffs in Jacob, but it's also it could be important news for DV 2021 selectees who are not plaintiffs in Jacob. They could get relief following the July 15th hearing, just as the plaintiffs could, even though they are not plaintiffs, because of the renewed motion for class certification. Okay, so if a class is certified, that means the judge says the class is okay by Judge Chen, he could potentially give relief to DV 2021 selectees who are Jacob plaintiffs, and like different relief, even unprioritized relief to non-Jacob plaintiffs. Okay, so Jacob plaintiffs decided through a vote that their class definition would not include plaintiffs in other lawsuits. Okay, that would mean Go, Ray, Good Luck, etc. So this is based generally, what they were thinking is DV 2021 selectees who are plaintiffs in other lawsuits already have a path to relief in their other lawsuits. So they didn't feel like it was necessary for them to sort of like commandeer or take over those other cases. So don't jump to conclusions about what this will mean with visa issuance after orders, because ultimately it is Judge Chen who has the power to define the class. So we don't even know how it will be defined until he does that, okay? He can make it more restrictive definition, or he can make it broader, okay? He could make it broader than what the Jacob plaintiffs proposed if he wanted to. He could even decide not to certify the class. We do not expect his decisions on these motions in the Jacob v. Biden case prior to the July 15th hearing. So if you're looking for news from Jacob case, it's only going to be procedural until after the July 15th hearing. Okay, Judge Chen also ordered the parties to meet and confer to see if they can stipulate to relief. What this means is he asked us to try to work out an agreement with the government. Let's be reasonable, so that he would not have to make a decision and we could just move on. Well, that does not work with this particular defendant on this particular issue. I've proposed, I think, 5 times now, and the government's not interested. So, okay, second, let's talk about Ray versus Biden. That's the lawsuit that Rafael and I filed in March. The Ray lawsuit is unique because it was filed on behalf of DV 2021 selectees who also faced bans like, or what are called the Schengen ban, regional bans, as a barrier to visa issuance. Shortly after we filed the case, filed the lawsuit, the State Department actually changed their policy and decided that all immigrant visa applicants have a national interest exemption to the Schengen ban and those kind of regional bans. So that might not be a barrier for them anymore. However, the majority of Ray v. Biden plaintiffs who are DV-2021 selectees, like the majority of DV-2021 selectees generally, have not yet been scheduled for interviews. Okay, so we continue to fight in that case. So in a telephone status conference held maybe 2 weeks ago on June 10th, Judge Chutkan, who's the judge in the Ray case, told Raphael directly that she would try to issue a decision on our motion for preliminary injunction as soon as she could. Okay, that's the word she used, as soon as I could. So that's a good sign. It's probably forthcoming soon. So we are hopeful that it comes soon. And Ray v. Biden is not a class action lawsuit, unlike Jacob. So the order in Ray v. Biden lawsuit will likely only impact the Ray v. Biden named plaintiffs. Okay. So if you're not a plaintiff in any of our lawsuits, there's the one you would want to watch is Ray, not Jacob, or the third. So let's talk about the third lawsuit that we filed. We filed Good Luck v. Biden. Raphael and I filed that on June 6th. Okay. The Good Luck v. Biden lawsuit is a lawsuit that is not like any other lawsuit. We will concede that. Plaintiffs are over 11,000 families, making up over 24,000 plaintiffs total, all DV-2021 selectee families. They come from over 141 countries, so a very diverse group. If you're a Good Luck plaintiff, you're a part of a very diverse group. On June 16th, we filed the motion for preliminary injunction in that lawsuit. Judge Mehta, the judge assigned to the case, has already ordered the parties, that's the lawyers for the government and us, to meet and confer, to propose to the court, to propose to the judge, a briefing schedule that would resolve the motion. Okay? That proposal is due on Tuesday. I expect that meeting will happen today. So, Monday. So plaintiffs obviously want the briefing to happen as quickly as possible, and so we could get relief as quickly as possible. And we expect the government might not agree with that. Ultimately, however, it is Judge Mehta. When you go to court, it doesn't matter what the government says. They are the defendants as much as what the judge says. The judge is the decider. Okay, so he will make the ultimate decision on that. He will also decide if there's a hearing or not. Some of you new to watching lawsuits may not know this. A hearing is not required. A judge can make a decision without a hearing. Judges usually have hearings if they have questions. Judge Mehta is very knowledgeable about the current state of the DV program, by the way. He was the judge who gave relief to DV-2020 selectees that we represented last year, primarily in Mohammed and Fongjiang cases. And in another order on the last day of September, he also carried over 9,095 DV-2020 visa numbers past the fiscal year deadline. And we're hoping to get many of those for our Kennedy v. Biden plaintiffs. So we hope and expect those visas will be issued to DV-2021 selectees following the final judgment in what's called the Gomez consolidated cases, but that's not happened yet. But I digress. That's a distraction. We're talking about the DV-2021 lawsuits now. So also Judge Mehta is the judge in at least one other lawsuit for DV-2021 selectees. But we do not expect, I get asked this a lot, we do not expect Good Luck to be consolidated with any of those lawsuits because those cases are in different places procedurally and those plaintiffs are pursuing different legal strategies, and it might not save the court any time to have us in the same hearings. Okay. So thank you for listening to this update about our 3 DV-2021 lawsuits. We hope to be back soon with good news for plaintiffs in all 3 of these lawsuits. In the meantime, I would like you to remember to drink water and breathe air. There will be many little procedural developments along the way in a lawsuit, especially for the good luck plaintiffs that are joining us. So don't get excited and worked up about every single one, because in the big, long journey, they may not be that significant. Save your energy for the significant events, okay? Hearings and orders, okay? So thank you very much, and have a great week.